Hello, welcome back to this channel. Today we have mostly 5 topics to discuss for this class. In this class, it is about polity and governance series for current affairs. Now, you know, the main purpose of this series is that the students which are aspiring to be an IAS officer, or whether they want to be state civil servants or IAS, whatever they want to be. My aim is to, you know, connect them to the current affairs from last 1 year. So this is the 5th class of this series, and today we have mostly 5 topics to discuss. First, we will discuss about Uniform Civil Code, which is in news very often, and it is one of the most controversial law in our constitution. It is currently, it is placed in TPSP's Article 44. So before going to the details of this, I want you, if you are seeing this video, please, today's class is very important for both for your mains as well as prelims. There are few interesting topics in it, and there are few, which are not that much conceptual, which you have to remember. They are kind of dry topics in it. So please have a notebook with you and try to, write these things and try to remember these things. And it would be very helpful for you in your exams. So let's start. First, as usual, we'll go to the core of this news, why it was in news. It was back then the Law Commission of India sought suggestions from various stakeholders on Uniform Civil Code. If right now we would see why it is in news, it is because of the Uttarakhand, assembly, and they introduced it in their assembly. So let us see what Uniform Civil Code has to give us, what are the controversies related to it, and those who support it, what are the points they are giving to us, and what are the points they are trying to prove for the adoption of Uniform Civil Code. Let us go one by one. As we can simplify it in simple terms, it is the one common law for the people of belonging to all religions, all places. Usually when we talk about the law in India or overall in the world, there are a lot of diversities in religion. We have cultural laws, we have religious laws. So there are many contradicting things in them, which others may find it very controversial. So to overcome these things, especially in India, when we see the diversity of the religion here, there are multiple religions presently in India, and all have their scriptures and all follow their religious orders for their civil affairs. But for your information, I want to say one thing. For our criminal laws, we have IPC and CRPC. Those are for everybody. On criminal crimes, their religious or cultural laws does not have anything to say. It is the national laws or the constitution which has to say in those areas, like IPC and CRPC. Coming back to this, it is one law for entire country which would apply to all religions. uh, in their personal matters such as marriage, divorce, inheritance, adoption, and succession. For example, if I would try to expand it here, if we would see the marriage laws of different religions, we follow different. For example, in Muslim community we have polygamy, which is allowed. A man can have multiple wives to the extent of four. And for Hindus, that they are not allowed to marry second wife. They can't marry more than one wife, and similarly for Christians also. So I think it is same for the Christians also. They are not allowed to marry more than one unless there are few criteria, especially when we talk about Hindu law. If a girl at the age of uh, at the if if a girl at the age of 25 she is not able to give a birth to a male child, the man can go for the second wife then. So these laws are codified according to their religion. For Muslims, they can marry more than one wife. For Hindus, you know, they have under special circumstances they can go for polygamy. So since there are, these laws are varying for different people, for different beliefs. So to you know which is the diversity of our country, and it is very at the same time the supporters of uniform civil code say that it is very controversial. It leads to the divide of the nation, and it lacks unity in the nation. So to overcome these issues, they want to bring the civil code which would be prevailing to everybody, which under which everybody has to obey, and those laws would you know overcome their personal laws. Similarly, in divorce, we have different norms, we have different ways, and succession, inheritance, all that. Currently, Indian personal law is complex with, as I said, with each religion adhering to its specific law. For example, I told you about Hindu Succession Act 1956, Muslim personal law, which is actually the Sharia law, Indian Succession Act 1925, which applies to Christians, Parsis, and Jews. Earlier, before this, the Law Commission had furnished a consultation paper on reform of family law in 2018, which stated that a UCC, Uniform Civil Code, was neither necessary nor desirable at this stage. It is very important if we would discuss about this line, which I would mention, which is here. The Law Commission had furnished consultation paper on reform of family law, which stated that UCC was neither necessary nor desirable in 2018. Before, if you have to bring any big change in the society or in the nation, first we have our people who are living there. First you have to impact their mentality regarding these issues. If you would remember, I can relate it after when Jallianwala Bagh incidents took place, and Mahatma Gandhi, he decided for the non-cooperation movement, I guess. Yeah, then Mahatma Gandhi decided for the non-cooperation movement, which started then. But an incident which which took place during that time, it was Chora Chor incident. After that, Mahatma Gandhi went for he stopped the movement. And you know what was the main reason for that was the public was not ready for the mass movements then. uh, I know there is no direct connection between this, but right now for the UCC to be applied, our public is not ready to accept it. The people are not ready. They are very much involved in their cultural laws, and it would have very harsh impact. Then, so this is what, in nutshell, Law Commission said that UCC, it is neither necessary right now nor it is desirable. And if we would see only state which had a similar kind of law, which we can say it is a uniform civil code, it is in Goa, which is Portuguese Civil Code of 1867. If anybody, if a Muslim guy is married there, Muslim man is married there, he can, in Goa, his marriage is registered in Goa, he cannot go for the polygamy. So this was little bit about the Uniform Civil Code. It comes under Article 44, Directive Principles of State Policy. And let us discuss further what are the arguments which are in favor of Uniform Civil Code. You know, it has a constitutional mandate. When the framers of the Constitution, they deliberately put it in the directive principles. They knew that sometime the masses will get ready and it would be applied then. So it is under directive principles of state policy. And what are the, what those who favor UCC, what is their second point in it? They say that it promotes secularism. It implementing UCC would uphold the principles of a secular state where religious beliefs do not dictate civil matters. Here we have, if here we have different definitions of secularism as in Western countries and then in India. The definition for Western countries about secularism is they keep religion to the people itself, and they have nothing, no role in it. In fact, if there is only one religion, that is Christianity, and other they have different they have no particular role in their religion. Their polity is different, their governance is different, and they keep religion to very basic, to very basics. But in India, our secularism is way much different and way much superior. Here every religion here we have diversity of religions. Every religion is respected, and our laws do, we our governance does have impact on the religious laws. For example, if we will see Sabaramalia case, uh, Kerala, we will see there. If we will see instant triple talaq, we will see different incidences where constitution, where government fell into, went into the religious laws, and they, and what we say, they filtered the things out which they assumed that they were dangerous, or which they assumed that they were discriminatory towards certain groups. So what here the writer wants, so what he is trying to imply, what the argument which is in favor of UCC, they are promoting by promoting secularism, they are shifting towards the Western secularism. Then we have third important point in it is national unity and integration. The supporters, they argue that because of UCC, our nation will get more integrated, it will get more united as it is right now. They say that UCC would foster national unity by transcending religious and community divisions. As it is prevailing in our country, we have religious divisions, we have caste divisions, we have even divisions in the religion. For example, if you are of different castes, some are of different castes, there is it is not only the religious divisions in our country, there are various kinds of divisions, caste divisions. We have state-wise divisions also. We have sector-wise divisions also, and they are very discriminating. For example, we have north-south division. There are many things which are prevailing in our country, and one among them is the religious division, which is currently we are discussing about. Then the writer further says it would promote gender justice. For example, different laws of religion, they see, their definition for equality is different, and the modern definition of equality is something different. So what the supporters of UCC say that they what are the present norms of equality, justice. They want to bring that all over the places. They want to, you know, they want that those norms to be put in the religious laws. They want, the divisions, what they think, which religions, promote, the distinctions religions promote, or simply the gender bias, what they think religions promote. They want to overcome these things and bring it to the modern definitions of gender equality, justice, and all that. And then one more thing, what argument which is in favor of UCC is simplification of law. If we will see different religions, they have different ceremonies, they have different ways of doing their business. It would simply simplify the laws around marriage ceremonies, divorce, inheritance, and succession, etc. And it would help to adapt to the modern times. These are few arguments which are in favor of UCC. Now we would see what are the arguments which are against you, those who don't want UCC to be implied, at least right now. What are their arguments related to that? First, it is against the diversity. We in our country, the main and the most beautiful thing, it is about the diversity of India. It is the diversity of our country. And if anything, and the sentiments for the people regarding their belief system, it is very hard, it is very deep. And if anything which would if they would think that anything brought by the government or by the law which would be discriminating towards them, if they would think they are interfering in their personal laws, it would create a chaos. It can lead to a chaos. So it is against the diversity. Diversity is to be respected. Because of the diversity, the country becomes the beautiful country. It becomes the livable country. It is because of the diversity. So, and definitely it is against the diversity of the country. Then there is a lack of consensus. Each community has traditions, customs, religious laws they wish to preserve. It is in nature of the humans that they want to preserve their things, their generations, what they are believing in. For example, different cultures have different way of living. They are preserved different. We have different languages. They are very much proactive towards their languages. They cannot tolerate anything less towards them. So people are like that. We have different faith system, and we are very much you know deeply rooted to our systems, deeply rooted to our cultures. So it does not, if we would bring UCC, it does not respect that thing. It would lead to some, as I earlier mentioned, that it would be very much, it can lead to the social unrest. So this is one of the argument against it. And then it is definitely against the federal structure. Several experts they argue that UCC could encroach upon state legislative competence, thereby infringing on principles of cooperative federalism. It is also argued that states are better positioned to assess and legislate personal laws to suit their people's needs, given their proximity to grassroots realities. So states, they know what their people like, so it should be within their domain, and they should be allowed to do whatever would be good for their people. So it should be the states who should decide whether to bring it, whether to implement it or not, because they have the first hand experience of it, first hand knowledge about it. Now we will see uh, what are the way forwards. First, a consensus. Government must engage in a constructive dialogue with all stakeholders, whether they are the scholars of their different religions, leaders of different religion community, respectively. They should engage with all those representatives. Then there should be a strong political will. Government must ensure that the implementation of UCC is not used as a tool for political gains. This is one of the most, critical point in it. It should not be used for the political gains, and that is that it is undertaken in a non-partisan and inclusive manner. Everyone has to be included. It consensus should be there, and all the impacts of it should be well studied, and then after they should come to some conclusion. Awareness. The common citizen must understand the rationale behind UCC and benefits. Usually when any controversial law is brought in or is discussed, people have different opinions, and usually minorities frame every law. If any law is formed, they frame it as against their belief system. It is against their existence, or we can say belief system. ये उनके खिलाफ बनाया गया है. This is their, it is this mentality is for every minority. They believe whatever law is brought, they think that it is against them. So there should be a very comprehensive awareness spreading. Awareness should be given to the common people. What is their reason why they are bringing the UCC, if they want to bring it, and what are its benefits. This will require a great effort by the government. Civil society has to be engaged, and the media has to, they have to play this very sensibly. They have to be very sensible towards it. Then, eradicating discrimination. It is essential that, it is very much essential that UCC requires a thorough review of the existing personal laws to ensure that UCC is in line with the principles of justice, equality, and non-discrimination. Then one important thing is about adopting a piecemeal approach. So let's see what is the goal of the UCC should ideally be reached in a piecemeal manner, like the recent amendment on the age of marriage. This could also pave the way for internal reform and change within the religious dispensation. First, it should not be very abrupt. It should be very much, first they should look into the, you know, they should look into the laws one by one, study them, and if any law which is controversial, they should start, amending them. Then after and this process should be, there should be a piecemeal approach, as it is here. Like the recent amendments about the age of marriage and other amendments in the uh, personal laws of different religions. And one more thing, codification of all personal laws should be there. All personal laws should be codified so that one can establish universal principles that promote fairness instead of encouraging a rigid uniform code which may deter people from restoring to legal resources, as marriage and divorce matters can be resolved through extrajudicial means. There should be proper codification about the laws, how they, what are the principles, and that everything should be well codified. So by that, it would make very much. First, we have to understand, in codification we have to understand the different personal laws, and according to that we have to come to the final conclusion. So before going into next topic of today's discussion, first we would see some, what is the background of Uniform Civil Code. If pre-independence era, we will see Lex Lucy Report 1840, in which emphasized the importance of uniformity in coding Indian law related to offences, evidences, and contracts, but it recommended that personal laws of Muslims and Hindus should not be codified. And this is Lex Lucy Report 1840. Then we have B.N. Rao Committee 1941. It recommended a codified Hindu law. It is 1911, I guess. It recommended a codified Hindu law which would give equal rights to women. Then post-independence period, we have Special Marriage Act, have proposals for civil marriage for people of India, which has Special Marriage Act 1954, which has proposals for civil marriage for people of India and all Indian nationals in foreign countries, irrespective of religion or faith, followed by either party. Then we have 4 major enactments on Hindu laws. For example, Hindu Marriage Act, Hindu Succession Act 1955, Hindu Minority and Guardianship Act 1956, Hindu Adoption and Maintenance Act 1956. So these are few laws which we should know when we discuss about Uniform Civil Code. So I guess for today's discussion on Uniform Civil Code, it is more than enough, and I won't be surprised if a question would be asked in mains or in prelims itself. And by when we go to different in upcoming class, we would discuss it further, because we had discussed Uniform Civil Code and the Uttarakhand. So it would come again, and we will see if anything would be missing. We will cover that in next next discussion about this. Now let's move to the second most important topic of today's class. It is about judicial pendency. So why was it in news? Let us see that. The Ministry of Law and Justice recently informed the Raj Sabha that over 5.02 crore cases were pending in various courts. It is not a joke, 5.02 crore cases are pending in various courts. So Let us see what are the reasons for the pendency of cases. And what is judicial pendency? It refers to the clogged state of judicial system in India, where the quantum of litigation is spiking exponentially, but the output in form of judgments or setting of disputes moves at the slow pace. Judgments given are very slow, but the cases are getting filed exponentially. Now let's go to the reasons for pendency of cases. We have low ratio of judges to population and delay in filling the vacancies of judicial officers and judges. It is all data. We have frequent adjournments of the today this court would be adjourned. You might have heard it many times in movies. We have frequent adjournments in the cases. The laid down procedure of allowing a maximum of 3 adjournments per case is not followed. Maximum of 3 adjournments were laid down, but this is not followed. There are multiple adjournments to the cases, which leads to very much time consuming, and because of that further cases pile up, and uh, timely judgments are not given. Then we have lack of infrastructure. Court complexes lack adequate funds, internet, and courtrooms to occupy judges if new appointments are made. So the infrastructure, if you would had seen the district courts or sub district courts, you would see that how uh, you know how what we can say कितना मतलब कि वो कितना कंजक्शन रहता है वहाँ पे, और हाउ मच कितना मतलब कि वहाँ पे कितना रश रहता है लोगों का. We would see by going there. I hope none of you visit there for any case, because it is not easy. But if ever you have to go there, you would find the congestion there and all that stuff. Then we have one more important is that there are delayed investigations, delay in processing both civil and criminal cases due to non-availability of counsel, misaligned incentives, the complexity of facts involved, nature of evidence, etc., leads to rising judicial pendency. And one more thing is abusing contempt of court power. Usually judges do that, and improper courtroom behavior, etc., that also leads to the pendency, that leads to the adjournments, that leads to time consuming. Lot of time is wasted on a single, which could be very easy judgment. What courts do, they take very much time. And recently Supreme Court of recently Chief Justice of India, Honorable Chief Justice of India, what he said, that trial courts, they take lot of time regarding the cases, and they are not giving bail to the people. Well, he further added that bail should be very much easily available, but they are very hesitant to give bail, and that also leads to huge number of under trials. It is very much depressing if we will analyze this thing, this pendency of cases. How many people, if a innocent man gets involved in it and he has to follow this procedure for years, the trauma he goes through, and finally after a few years, 10 years, the court says that you are innocent, we are sorry that you were held here, but we cannot give your years back. It is very much depressing. So there should be fast tracking in it. The judgment should be very much, should be given very quickly and comprehensively. They should be studied very well, but unnecessary breaks should not be taken there. Then we will see what is the way forward in it. Appointment of judges. and this is very important. Collegium should take adequate safeguards and transparency in selecting judges, so that judges of high caliber and impeccable integrity are appointed to the higher courts. Then we have all India Judicial Service examinations can be considered to maintain high standards in the judiciary, and also Article 224A and 128 of the Constitution can be invoked to appoint ad hoc judges. And these are related to ad hoc judges appointment. Then we have promoting alternate dispute resolutions such as lok adalats, arbitration, mediation, conciliations, etc. for civil cases can help to reduce the burden on courts and facilitate robust legal practice. Then we have strengthening infrastructure. Government should provide adequate funds for developing and upgrading the judicial infrastructure, training judicial staff, etc. We have setting a time limit. A time limit should be set for hearing a case and deciding. Then changes in criminal justice and procedural laws should be brought in, reduce the criminalization of violation, and reforms forensics and ballistic testing. There should be grievance redressals. Government departments must establish a strong internal grievance redressal mechanism and empower designated officers to decide disputes between employees and departments. We discussed this in our previous class about a grievance redressal mechanism. And they should create a law-abiding society. This is about the causes of these huge pendency of cases, and these are few way forwards which should be brought in to deal with them. Now we have to discuss about one of the important institution, that is Directorate of Enforcement. Usually if you are following your daily current affairs, you are reading your newspapers, or you are watching these daily news analysis videos, you would at least once in a week you would come through this term Directorate of Enforcement. It is usually in news and it has a huge work to do. Let us see what it does, why it was in news, and what we have to know about it. Recently Supreme Court declared the third extension given to the Directorate of Enforcement chief invalid. First, we should know that this the chief of Directorate of Enforcement, he was given third extension, but Supreme Court made it invalid. But in laws, this is allowed. For example, we will see it ahead. SC upheld, Supreme Court also upheld the amendment to the Central Vigilance Commission Amendment Act 2021, Delhi Special Police Establishment Amendment Act 2021, and Fundamental Amendment Rules Act 2021. These amendments allow the tenure of directors of the Central Bureau of Investigation and the ED a maximum of 3 annual extensions. If here is the, here we can see the provision for the third annual extension, but why Supreme Court declared the third annual extension for the chief of Directorate of Enforcement invalid? Let us see what is the reason for that. First, we will discuss about the Directorate Enforcement. It is the multidisciplinary organization which is mandated to investigate economic crimes and violation of foreign exchange laws. It works under the Department of Revenue, Ministry of Finance. It is headquartered at New Delhi. Now, and the appointment of Directorate, this whole discussion, this article which led to this discussion. It is about the appointment, it is about the tenure. So we should know about the appointment of ED director of ED director is appointed as per provisions of the Central Vigilance Commission Act 2003. This might be asked in your exam, how ED director is appointed, and most probably this might come in the prelims. I won't be surprised if any question related to it is asked. Then about tenure, also it might also come. Tenure should be not less than 2 years, and any transfer has to be sanctioned by the appointment committee chaired by CVC. The mandatory 2-year appointment period is followed by a maximum of 3 annual extension. Maximum of 3 annual extensions are allowed after these two mandatory 2 years under the Central Vigilance Commission Act 2021. Now we would see what are the powers of Directorate of Enforcement. He has a power to seize assets. He has the authority to undertake search and seizure against any individual based on information in the officer's possession and by establishing in writing. Then he has power to summon. He has power to arrest. Can ED can investigate and make arrests for violation of the Prevention of Money Laundering Act 2022 and FEMA 1990 without waiting for registration of a formal FIR by police. It has a record of admissibility. What is that record admissibility? In 2022, the Supreme Court ruled that statements recorded by the ED officials can be admitted as evidence in the court, as they are not police officials and are thus not subject to challenge on the grounds of being self-incriminatory. So this statement may also come, this record admissibility, this may also be asked. Can their can statements recorded by the ED officials be admitted as evidence in courts? This might be asked in the exam. Then they can recovery of fines, penalties, and arrears of penalties. They have this right also given by the FEMA Act. Now we will see issues with the Directorate of Enforcement. It has abysmal conviction rate, very low conviction rate, 0.5%, as low as 0.5%. Lack of transparency. There is transparent whenever you have to write any issues with any government agency, please put this lack of transparency in it. It would be applicable to every question which is regarding these government institutions. Failing credibility. The image of investigative agencies like ED, CBI has been tarnished by allegations of corruption, has been tarnished by the allegations of corruption, lack of impartiality, and close nexus with the political class. These are few. They have lack of workforce in ED also. These are few issues with them. Then if we will see what are the way forwards, we should enhance capacity regulation. It should be well regulated, reducing pendency and oversight committee. A committee should be consulted to overlook and streamline the case selection process based on objective criteria and to boost transparency in the functioning of the ED. Awareness and protection. Public awareness should be generated about the ED's role, reform its image, and encourage whistleblowers to come forward. This was about the Directorate of Enforcement. Yeah, as I earlier said that the third tenure, which I forget to tell you guys that the third tenure, as it is allowed by the Supreme Court judgment, but why in this case it was not allowed. However, in this the Supreme Court argument is that the SC ruled that the current uh, uh, ED director, ED chief's term extension was unlawful for violating the mandate of the Supreme Court's 2021 judgment, wherein the court had barred further extension. In 2021 Supreme Court judgment, they had barred the further extension. So they say that it is the violation of that judgment of the Supreme Court. Now let's move to our next slide. It is Multi-State Cooperative Societies Amendment Bill 2023. Both houses had passed the Multi-State Cooperative Societies Amendment Bill 2022 to amend the Multi-State Cooperative Societies Act 2002. Now let us discuss what this Multi-State Cooperative Societies Act 2002 has to give us. What was the objective? Its objective was to consolidate and amend the law related to cooperative societies with objects not confined to one state and serving the interests of members in more than one state. Then what are its key provisions? Key provisions of the application. The Act applies to all cooperative societies with objects not confined to one state. Then we have registration. All MSCS multi-state cooperative societies shall be registered under the Act through a central registrar appointed by the central government. So remember this, all multi-state cooperative societies shall be registered under the Act through a central registrar appointed by the central government. Internal governance, it was a provision of 2002 Act that every multi-state cooperative society may make its bylaws consistent with the provisions of this Act for its internal governance. Then we have reorganization. Central register to prepare a scheme of amalgamation or reorganization of cooperative bank. This is done on the direction of the central government with the prior approval of RBI and in accordance with the Banking Regulation Act 1949. Now let us see what was the need for the amendment. Bill. Consistency with the Part 9b. MSCS Act needs to be amended to bring consistency with the Constitution 97th Amendment Act 2011, which incorporate Part 9b in the Constitution of India. Then we have fulfillment of cooperative principles, which aims to plug loopholes in the existing legislation and strengthen governance in the MSCS in multi-state cooperative societies in accordance with the cooperative principles. Then need for reforms in MSCS, easier and digital registration process should be there, more vibrant and active membership should be there, increased transparency through information officer. As I said, transparency would be everywhere, you have to put it. What if way forward you have to write what is your solution, put this transparency everywhere, it is valid. Then revival of SIC MSCS multi-state cooperative society through a dedicated fund. A SIC multi-state cooperative society is one that has accumulated losses equal to or exceeding the total of its paid up capital. इतना लॉस हुआ होगा, free reserves and surpluses and suffered cash loss in the past 2 financial year. That we, if any cooperative has these unfortunate things, then we call them SIC cooperatives. I would once again repeat it. Accumulated loss equal to or exceeding the total of its paid up capital. जितना इन्होंने paid up capital दिया था उससे ज़्यादा इन्होंने हारा है. Free reserves and surpluses. Further, cash suffered cash loss in or from last 2 years they are suffering cash losses. Now let us see what are the key features of the amendment bill. It establishment of cooperative elective authority. Presently, the elections to the board of a multi-state cooperative society are conducted by its existing board. But bill specifies that the central government will establish the cooperative election authority to conduct elections to the board of multi-state cooperative societies. So establishment of cooperative election authority. Then we have amalgamation and division of cooperative societies. The act provides for the amalgamation and division of multi-state cooperative societies. The bill allows cooperative societies registered under state laws to merge into an existing multi-state cooperative society. So amalgamation and division of cooperative societies. Then fund for sick cooperative societies. This is one of the key feature of the bill. And we have restriction on redemption of government shareholding. Presently क्या होता था, the act provided that the share held by a multi-state cooperative society by certain government in a multi-state cooperated by a certain government authorities can be redeemed based on the society's bylaws. But this bill amends this to provide that any share held by the central and the state government cannot be redeemed without the shareholders' approval. Then we have redressal of complaints. As per the bill, the central government will appoint one or more cooperative ombudsman with territorial jurisdiction. Appeals against the directions of the ombudsman may be filed with the central registrar. Then we have composition of board of directors. Under the act, the board of multi-state cooperative society will have maximum of 21 directors. The board may opt for 2 additional directors. The bill also amended the composition of the board of directors to mandate the inclusion of 1 scheduled caste or scheduled tribe member and 2 women members. Gender empowerment and inclusiveness for everybody. So this was about multi-state cooperative societies. Now to our last and very dry topic of this discussion, we have to go to. It is about Cinematograph Amendment Bill 2023. Similarly, both the houses passed this Cinematograph Amendment Bill 2023. Let us see about it. This bill amends the Cinematograph Act 1952, enacted to make provisions for certifying cinematograph films for exhibition and regulating exhibitions using cinematographs. It amended the Cinematograph Act 1952. Another thing which we should know, Act provides for establishing the Central Board of Film Certification for certifying films for exhibition. It also provides for the Central for exhibition. The Act provides for the establishing the Central Board of Film Certification for certifying films. This is what this Act provides for. The proposed amendments aim to make the certification process more effective and in tune with the present by introducing new certification categories. Now let us little bit discuss about the Central Board of Film Certification. It is a statutory body under Ministry of Information and Broadcasting. These questions UPSC often ask. Under which ministry it does come. Usually I had learned a trick whenever they give any option regarding these ministries. Mostly any question where a ministry is mentioned, mostly chances are, if you don't know that, assume that it is wrong. usually they mention wrong ministries with in their statements. This is the trend of UPSC. Cracking prelims, it is not just about knowing everything. It is about how smart you are and understanding their trends. They deliberately put those things in their papers. They want to see how smart you are. When they set a paper, it is not just setting it to check your knowledge. No, it is not. If they would set it to check your knowledge, trust me, nobody would qualify the exam, because knowledge is not limited. Our syllabus cannot is not limited. Yeah, we have the boundary around which we have the boundary inside which we have to study, but the depth is very deep. How how far can you dive in? It is not possible for anyone. If there is some extraordinary person, extraordinary aspirant, he cannot remember everything. So if UPSC has to fail you, they would if they would start framing their papers to check your knowledge, trust me, nobody will qualify. Only few. Then cutoff rate would be 10 marks, 5 marks. Only those वो तो केसेस जो पास होंगे वही पास होंगे, और पढ़ाई से कोई पास नहीं होगा. But UPSC is, they are very much they are very intelligent, and they frame their papers very intelligently. They want to check how smart you are. They want to check whether you had understood the trends. And if you had understood the trends, you can easily qualify without knowing the proper answers. So, this I had understood it. If you don't know, if your knowledge about these ministries is you don't know much accurately about the question, then most probably, it would be wrong. So for further such details, please join, ask in comments. If you are reaching here, अगर आपने इतना सुना है तो आपको पता चलेगा. Please ask me in comments. In further classes I would give you some few more tricks which we should master and which would help us in qualifying the exam. So here we were Central Board of Film Certification. It is a statutory body which is under Ministry of Information and Broadcasting. It regulates public exhibition of films under provisions of Cinematograph Act 1952. Then we have vision to ensure the good and its vision is to ensure the good and healthy entertainment in accordance with the provisions of Cinematograph Act 1952 and Cinematograph Certification Rules 1983. Mission: make certification process transparent and responsible. Then composition consists of non-official members and a chairman, all of whom are appointed by the central government. This was a little bit about Central Board of Film Certification. Now, what are the key provisions of the amendment bill? Here we have age-based restrictions. For example, universal A standard U stands for universal, A stands for adult, UA without restriction. But we would decode these things first. What we can see here, UA. Now we should know what U stands for. U stands for the universal without any restriction. UA, it is also without any restriction but subject to guidance of parents or guardians. Then A, only for adults. Let's go to the key provisions. Age-based certification bill introduced 3 age-based certification under UA category: UA 7 plus, UA 13 plus, and UA 16 plus. These age-based markers meant for parents or guardians to consider whether their children should view such a film. They are only recommendatory. So remember this term, they are only recommendatory. Then we have separate certificate for television, other media. Films with an A or capital A or capital S certificate will require a separate certificate for exhibition on television or any other media prescribed by the central government. So A is for adults, S only to members of any profession or class of persons. So if these A and S are mentioned, S is for only for the members of any profession or class of persons. Then we have certificate to the then separate certification for television media. We have revisional powers of central government. Bill, revisional bill omits section 6(1) of the act as directed by Supreme Court in Union of India versus K.M. Shankarappa case 2000, which states that center cannot exercise revisional powers on film, but central cannot exercise revisional powers on film already certified by the CBF. So section 6(1) of the act was omitted. What section 6(1) of the previous act said, that center used to exercise revisional power on films which were already certified by the CBFC, but in this amendment this section 6(1) has been removed. It also makes film piracy a punishable offense. And this bill prohibits the unauthorized recording and unauthorized exhibition of films and makes it a punishable offense under the provisions of Copyright Act 1957, and penalties will be imposed on the people who violate these things. So this was about today's class, and I hope you had understood it. This is these classes are very important for you, for your guidance in your exams. It takes very much hard work to make these PPTs and deliver it, and I hope you would appreciate this by liking it and by sharing it with your friends, and further by subscribing to this channel. Thank you very much. Have a nice year.